Spes Successionis. The easy meaning of this Latin term is chance of succession. It means that a chance of a person to succeed in the property of another person after his death. This is a mere possibility of succession of a heir to succeed in the owner's property. The chance or possibility does not create or confirm any interest in favor of the heir during the lifetime of the owner in possession. The concept of this maxim is found in the Section 6, Clause A of the Transfer of Property Act, 1882. Further, Section 6, Clause A of the Transfer of Property Act restricts or excludes any transfer based on Spes Successionis. Any transfer by Spes Successionis is void ab initio, even under the Hindu and Muslim personal law. Let us take an example. A is the owner of a house and B is his legal heir. B have the chance to succeed to inherit the property of A after his demise. A have the absolute right over the property. During the lifetime of A, B have no right or interest over the property. Now let us discuss the essential features of Spes Successionis. 1. It is the only a chance. 2. Expectation of chance to succeed. 3. Chance may or may not turn into reality. Why it cannot turn into reality? Because 1. Spes Successionis may die before the principal owner. 2. The principal owner may sell or give the property to the other. 3. In other way, the property may be devolved in favor of the other after the demise of the principal owner. There is a difference between the contingent right and Spes Successionis. The former is the actual right depending on the happening of a specified future event. On the other hand, Spes Successionis is the chance of succession. The difference between the Spes Successionis and the law of estoppel under the Transfer of Property Act are: 1. The basic difference between the two is that the transfer by Spes Successionis is void ab initio, but this transfer under Section 43 of the Transfer of Property Act is voidable at the option of the transferee. 2. In Spes Successionis, both the transferor and the transferee have the knowledge, but in case of law of estoppel, misrepresentation or erroneous transfer on the part of the transferor. Lastly, the law of estoppel is applicable for the transfer for consideration, not for the gratuitous transfer. In case of the transfer by Spes Successionis, both type of transfer is applicable. Number of cases had been decided by the various courts all over India and Supreme Court on Spes Successionis. Some of them are: 1. Shehamal vs. H.K. Rauther in 2011. 2. Jumma Masjid Merkara vs. K. Devia and others in 1962. This is a famous case. 3. D. Subba Reddy vs. S. Govinda Reddy and many others.